Everyone, and welcome to our latest Kuits HR Breakfast Club. This is our second Breakfast Club of 2021, and today's theme is all about returning to the office and next steps. For those of you joining us for the first time, my name is Tom Fairhurst. I'm Marketing Executive at Kuits, and I'll be your host for the next hour. Kuits is an award-winning commercial law firm operating out of Manchester City Centre, and one of our key specialisms is providing expert guidance for employers and HR professionals. For those of you who've attended one of our HR breakfasts before, welcome back. It's great to see you. We hope everyone finds today's session informative and engaging, and I will take you through the agenda for the next hour shortly. Before then, I just want to introduce you to our speakers today. From the Kuits employment team, we welcome Solicitors James Howarth and Lauren Ogden. And making her debut is new recruit and senior associate Claire Hollins. James and Lauren are going to present some recent case law updates this morning, and we think that'll be of interest from the world of HR and employment. And Claire is going to present our HR hotspot, looking at returning to the workplace and considering some issues like hybrid working, reluctant employees, holidays and furlough. We're also really pleased to introduce our guest speaker today, who is Gary McIndoe. Gary is Managing Director of Latitude Law. Latitude Law are a Manchester-based specialist immigration practice. And Gary's going to talk to you about the benefits that the EU settlement scheme can still offer to your employees and the alternatives available, including sponsored work visas. So like I said, I'll quickly take you through the agenda for the next hour. Just finally, from me, there'll be some ways to connect with us moving forward and a little bit of housekeeping. We'll do the case law updates with James and Lauren. It'll then be over to Claire for this quarter's HR hotspot, and then on to Gary for his guest speaker slot on UK work visa options. So just quickly before we get started, some additional ways to connect with us moving forward. So like you can see on screen, phone number, email address. Also the Kuits website. On the Kuits website, you'll find a number of insights, not just from our employment team, but from across the firm and all the departments. And then also there's an option there to sign up to our mailing list if not already. And also to say that Kuits has 3 active social accounts on Twitter, LinkedIn and YouTube. So if you're active on any of those, please follow us. This webinar is being recorded and will go out on the Kuits YouTube channel, and that will be sent to you as a follow-up. And just to say that the previous 5 Kuits HR breakfast recordings are on there as well, including the last one where the theme was no job policies. And then just finally to say that we have got quite a tight agenda today with a lot of information coming across. So if you do have any questions, you can submit them in the Q&A box at the bottom of your screen. And if we don't manage to get to them during the course of the next hour, we will follow up with you after the call with any questions that you may have. And like I said, if we do have a bit of time at the end, we can invite some questions for you to put to the panel. And then finally, just to say, there will be a follow-up email. There will be a follow-up email on the back of this webinar that will have all the information you need. So it'll have the contact details of all the speakers from today, a link to sign up to our mailing list, and also a link to a feedback survey as well. So I'd be really grateful if you would give us some feedback on this. Let us know maybe any content you might want us to cover in the future, or any areas you think that we're doing well or might be able to improve your experience and engagement. And that's it from me for now. So we can get over to hopefully the reason you're here is for some engaging content. So I'm going to hand you over to James Howarth for our first case law update.
Thanks, Tom, and good morning, everybody. So the first case we're going to talk about today is a case that I think has really captured the media attention, and it's it's a case of Kane versus Debmat Surfacing Limited. I mean, I've seen articles about it in the BBC and Telegraph, so I suspect you'll have probably read about it. So it's a case where an employee was dismissed for attending a pub whilst on sick leave. So Mr. Kane, the claimant here, had been employed for nearly 8 years by the date of his dismissal. So he was a smoker and unfortunately suffered from chronic obstructive pulmonary disease and had done so for several years. So this had caused him to be frequently absent from work. And the most recent absence, and I suppose the most relevant absence, was between the 9th of March and the 30th of March. So despite being on sick leave, the claimant was seen by a colleague in a social club drinking and smoking on the 9th of March. And that colleague reported that sighting to the business. And shortly after that report, the managing director for Debmat, a gentleman called John Turner, called the claimant asking him about the sighting. And the claimant denied going to the social club on that day and said he was actually stuck in bed at home because his chest had been particularly bad. So shortly after that, Mr. Turner then sent a letter to the claimant. And in that letter, it stated that the business was very concerned that the claimant had, in fact, on several occasions attended that social club while supposedly on sick leave. And the letter set out saying that was both inappropriate and a breach of company rules. So eventually, the claimant was invited to a disciplinary hearing. And in that hearing, he was asked about the absence. And the claimant denied going to the social club on the 9th of March, so when he was seen. However, did admit going to the social club on 2 occasions whilst on sick leave. But he was adamant he was never there for more than 30 minutes at any time. In that hearing, Mr. Turner said to the claimant that he had a picture, a photograph showing the claimant both smoking and drinking in the social club on the 9th of March. However, he never showed that photograph to the claimant at any point during those proceedings. So eventually the claimant was dismissed. So Mr. Turner concluded that the claimant had in fact attended the social club on numerous occasions while supposedly on sick, and they concluded that was both a willful and serious breach of company rules, sufficient to be considered gross misconduct. So the claimant brought an unfair dismissal claim to the tribunal, and the tribunal decided that he had in fact been unfairly dismissed. So I have to say, when I first read about this case, I was somewhat surprised at the outcome. As we'll all know, one of the key tests for a fair dismissal with somebody with more than 2 years service, it is essentially that the dismissal was within a range of reasonable responses. And looking at the facts of this case, you would very much expected that Debmat would have been able to demonstrate that. However, once you look at this case a little more closely, you realise that they made a number of fundamental mistakes. So I've just picked out a couple of examples from the judgment that I think are all quite relevant. So Debmat didn't undertake any proper or full investigation whatsoever. They didn't take any witness statements, any witness reports. They didn't even take a witness statement from the colleague who had apparently seen the claimant on the 9th of March. And also, they relied on that photograph as evidence to dismiss him, and that was never provided to the claimant. And again, that kind of undermines a fair dismissal if the claimant doesn't know the evidence against them. Also, they made a number of assumptions about the claimant's health and his medical condition, essentially deciding that by smoking and drinking, the claimant was exacerbating his health, therefore extending his absence. But they did that without any medical advice whatsoever. And finally, and I suppose probably most importantly, it was very clear from the beginning that this decision had already been made before any disciplinary process had started. So once Mr. Turner had called the claimant and written to him, essentially saying that he was guilty of going to the pub, it kind of undermined the rest of the process. And I suppose it didn't particularly help that Mr. Turner did both the investigation and the disciplinary process, which I say kind of there's a presumption of bias throughout if that does happen. So this is a classic case, I think, of an employer just getting it wrong, and whereas they would have had certainly grounds to get to what could have been a fair dismissal, but by not following a proper and fair process, they're always going to lose. So that's the first thing. I think I do say this in every case law update, but it's always worth saying again. Once you get any employee with more than 2 years service, even if you think the dismissal is obvious, you still need to do the basics and follow all the processes correctly. Otherwise, you might fail at a tribunal. The other interesting takeaway is that the tribunal decided that even if DebMat had followed a full and proper disciplinary process and investigation, well, actually, there's only a 25% chance that the claimant would have been dismissed. I mean, that seems quite low. But the reason for that is because DebMat couldn't sufficiently demonstrate that the claimant had lied about attending the social club. They hadn't undertaken a proper investigation to demonstrate that. And that was one of the key features of his dismissal. So that's the first thing. And the second thing, which I think is probably more interesting, is that he was dismissed for failing to follow company rules. However, at the tribunal, DebMat couldn't point to any document or policy that actually said what he did was expressly prohibited. So the takeaway from that, I think, is it's certainly worth having a look at your disciplinary policies, your sickness absence policies, and just making sure that you've certainly got something in there that expressly states that dishonesty about sickness absence will be treated as a gross misconduct offence. And secondly, I suppose slightly more intangibly, but secondly, have something in there that states that employees should follow GP guidance so as not to exacerbate any illness. And I think if DebMat had done both of those things, they would have been on much safer ground to dismiss in these circumstances. So I'm going to pass over to Lauren now for the second case.
Thanks, James, and good morning, everybody. So I'm going to talk to you about the case of Barrow against Kellogg, Brown and Root. Again, this has been one that has been in the media, mostly because the claimant was given an award of £2.5 million, which doesn't happen very often in the employment tribunal. So the facts of this case are that in September 2017, the claimant had been to see his GP regarding a skin condition which had continued to get worse. And by the November, his GP prescribed him a strong steroid to help with his condition. The steroid had an impact on the claimant in that it made him hyperactive and energetic, and it made him have a difficulty in sitting quietly to concentrate on his work. By the time that the claimant had been on the steroids for 10 days, they were at their maximum effect, and the claimant's emotions and state of mind were highly influenced by them. During this period of time, the claimant sent a 3-page email to his manager complaining that he felt undercompensated, demotivated, disadvantaged, and had been denied a meaningful promotion for 3 years. A few days after that email, the claimant advised his HR director that the medication had been having an effect on his general disposition and his emotional response to some situations. And so it was deemed appropriate that the claimant take some time off work to rest and allow the steroids in his system to reduce. He was referred to occupational health, who deemed that he was fit to return to work and that any causes of his stress could be dealt with management directly. His GP also signed him fit to return to work once the steroids had reduced in his system. On return to work, the claimant had a review meeting with his manager. The claimant left that meeting feeling disappointed that there were no discussions about his work objectives. And so again, he emailed his manager to raise this point, and he was advised that his manager didn't want to get into a lengthy discussion about this by email. In December of 2017, the claimant was then invited to a meeting in which he was told that the respondent could no longer employ him, and he was given 20 minutes to pack up his belongings and was escorted out of the office. Now, at the time, it was unclear whether the claimant was being dismissed or suspended or what allegations he was facing in relation to his dismissal. Fast forward to January 2018, a year later, the claimant's solicitor informed the respondent that the claimant had been diagnosed with lymphoma. And in March, the respondent invited the claimant to a meeting to discuss his matters relating to his employment. The claimant was about to start his chemotherapy and so could not attend the meeting that he'd been invited to. His solicitor sent a letter to the respondent advising them of how the treatment could impact the claimant's ability to attend those meetings and also having to cancel meetings at short notice. In April, the claimant submitted a formal grievance to the respondent and attended a grievance meeting. Following that meeting, the respondent made the decision to formally dismiss the claimant because of a breakdown in trust and confidence. The claimant then submitted claims for unfair dismissal, direct disability discrimination, discrimination arising from disability, failure to make reasonable adjustments, harassment, and victimisation. So the tribunal found that the dismissal had been unfair. There'd been no genuine attempt to investigate the claims about the claimant's behaviour fairly, nor was he given enough detail about the allegations he was facing. Witnesses were spoken to many months after the claimant had left the business, and the tribunal felt that that could have tainted their evidence. It was agreed that the respondent would have known about the claimant's illness and resulting disability when the solicitor informed them in January 2018 of his cancer diagnosis. However, the tribunal stopped short of finding that the company had directly discriminated against the claimant on the grounds of disability, because the alleged conduct in relation to this occurred before they were aware of his cancer diagnosis. The tribunal did, however, find that it had treated him unfavourably in relation to his inability to attend the meetings, and agreed that he had suffered disability-related harassment. Claims for failing to make reasonable adjustments and victimisation were dismissed. So the tribunal awarded the claimant £2.5 million, and this included £7,500 for aggravated damages due to the respondent's conduct. This is the second highest discrimination award that's been given. The tribunal accepted that this was one of the rare cases where it was appropriate to award career-long losses in addition to a significant injury to feelings award, as the claimant was 60 years old and had cumulatively worked for the respondent for 36 years. So the take-homes from this case are that it is important for employers to fully consider disability-related issues or concerns raised by an employee when making decisions about dismissal. They must ensure that their process is fair and that any disability-related issues are handled correctly at the time. And whilst awards of this size are rare, it is also an important reminder that there is no cap on the compensation for discrimination claims. And I'll hand you back to James for the final case or update.
Thanks, Lauren. So the final case we're going to talk about today is it's another employment tribunal case only, so not binding on other courts and tribunals. We don't often talk about these cases, apart from they're particularly interesting. And I think this one is particularly interesting because it relates to furlough, it relates to COVID-19 in the workplace. And we've not seen a huge amount of those cases yet. So I think when one does come through, it's always worth having a quick look at it. So this is the case of Akitatis versus Fortuna Group. And Mr. Akitatis, so the claimant here, he was employed as a marketing, it was a marketing and coordination salesperson. So essentially he sold personal protective equipment. And by the date of his dismissal, he had less than 2 years service. And his complaint was that he didn't want to commute to the office or even attend the office due to concerns about COVID-19. So he asked to work from home in the first instance. And Fortuna rejected that because they said that there were certain elements of his role that he couldn't do from home. And also there was a software on his systems in the office that couldn't be replicated on his personal systems. And in any event, it wouldn't have been cost effective or commercially reasonable to do so. So the claimant then said, we asked, can he be put on furlough leave instead? And again, the business rejected that. So what they said was he didn't qualify for furlough because there'd been no downturn in work. Actually, the business was particularly busy, as you can imagine, with a company selling PPE in April last year. So yes, the business said no to that, and he said that they were just too busy to allow him to go on furlough leave for a number of months. But what they did say, and this was quite important, they did say that if he really had those concerns, then he could take a period of unpaid leave or use his annual leave and obviously not come to the office during that period of time. The claimant, however, rejected that and continued to push to be put on furlough and essentially said he was not going to return to the office unless he was put on furlough. So eventually the business decided to dismiss him because he wouldn't return. And also they made it very clear to him that one of the reasons was they wanted to dismiss him before he got 2 years service. A bit cynical, but again, that's what they made clear. So because the claimant had less than 2 years service, he couldn't bring an ordinary unfair dismissal claim in the circumstances. So what he did instead, he brought an automatic unfair dismissal claim for being dismissed for taking steps to protect himself against danger. And he said that COVID-19 was, as per government guidance, was a serious and imminent threat to public health, and that justified his behaviour. So the legal claim that he brought is a Section 101E claim in the Employment Rights Act. So probably slightly unusual, but the claim essentially is that anybody dismissed, a dismissal will be unfair where an employee reasonably believes serious and imminent danger and takes appropriate steps to protect themselves or others from that danger, and they're dismissed as a result. So the tribunal considered this claim, and what they decided was COVID-19 clearly was a serious and imminent threat to health. And they also decided that the claimant subjectively believed that to be the case. So the first limb of that legal test was met. However, the claimant failed in the second limb, and that was because the tribunal decided that the claimant hadn't taken appropriate steps to protect himself, and he certainly hadn't communicated those concerns with his employer. So the key thing here was the tribunal decided that the claimant's main motivation was actually financial. It wasn't in relation to his health. What he wanted to happen was either to work from home at 100% pay or be put on furlough at 80% pay. If health was the real concern, well, actually, he would have taken the business up on its offer to take a period of unpaid leave. And the fact that he didn't undermined his case. So that's kind of the outcome of that case. I suppose the key takeaways are twofold. Firstly, I think with any employee who's raising health and safety concerns with the workplace around COVID, you need to be careful. I suppose it's pretty obvious. I think a reasonable employer would consider reasonable accommodation of certain elements of an employee's concerns. I think key here was offering a period of unpaid leave. I suppose that's the first thing. And the second thing, which I think is a bit more interesting, is in this case, the claimant, after he was dismissed, brought whistleblowing claims. So essentially what he did is, after he was dismissed, he raised concerns about his working environment, stating that it wasn't COVID secure and it was a threat to his health and his colleagues' health. So the tribunal decided that actually he'd only done that after his dismissal. He wasn't really making a protected disclosure and hadn't met the statutory tests. So that claim failed. But what's interesting is, I think we're going to see a lot more of that. I mean, certainly from what I'm seeing now is you're seeing a lot more employees with more basic tribunal claims, maybe a basic unfair dismissal or a basic discrimination claim. But what they're doing now is adding things on. So like whistleblowing claims around furlough fraud, unsafe working conditions due to COVID. I think this is going to be a trend moving forward. And the consequences are it not only makes a basic tribunal claim a lot more difficult, it also massively increases the compensation available to an employee as well. So again, I think it's just something to bear in mind moving forward. Okay, so that's it for the case law update now. I'm going to hand you over to Claire for the HR hotspot. Thank you.
Thanks, James. So what I'm going to talk to you about this morning is sort of considerations on looking on the return to the workplace, the sorts of things you may want to think about, may already have thought about and consider. And then we'll look at some sort of specific scenarios, so reluctant returners, issues around annual leave, and I'll touch on the changes to furlough as well. I'm not going to talk about vaccinations this morning and sort of the no job policies, because we covered that previously in the last HR breakfast, and that, as Tom said, that video is available on our YouTube channel if that's something that's of interest to you. So I think it's fair to say that before last March, the vast majority of employees went out to work. They went to a workplace. And of course, the pandemic has changed all of that. We started what's been known as the Great Home Working experiment. And of course, some 15 months on, the guidance for us all remains that where people can, they should work from home. Now, of course, we had expected that guidance to change at the beginning of this week, but the Delta variant has resulted in a change of thinking from the government, and now the home working guidance remains in place, and that's unlikely to change until at least the 19th of July, and there are some suggestions in some elements of the press that it may continue beyond that. So whilst we are in this sort of state of flux and not really knowing what's going to happen and when, no doubt some of you are already thinking about, have thought about what returning to your workplace will look like. And we've seen lots and lots of press coverage, particularly over the last couple of months, about this, sort of talking about the positives, the negatives of home working, depending on your point of view, possibly the nature of the person making the comments as well, and what their business impact may be. But what I think is clear is it's unlikely that one size is going to fit all. And that's both in terms of different employers, but also probably in relation to your own employees and your place of work as well. Now, I think what we're seeing is an over sort of riding trend is going to be towards the majority of employers looking at some form of hybrid or agile model. So does this mean that we're going to have flexible working as being the default position for everyone and we'll stop dealing with any flexible working requests? Well, possibly, but I guess it depends on how you intend to organise your workforce going forward. And of course, before the pandemic, and still the case, every employee who's completed 26 weeks service could make a statutory flexible working request, and that includes a change to their place of work. And of course, there was nothing to prevent you from taking a more flexible approach to that and allowing everyone to make those requests. And of course, you know, that does still remain the position, as I said, but the pandemic will have had an impact on this, at least in terms of the place of work. And of course, given we've all adapted to home working in the last 15 months, both in terms of the tools, the infrastructure to enable us to work effectively, if you want your employees to return to work and to your premises for the whole of their working time, what you may find is that you then see an increase in flexible working applications for those people who don't want to return to the workplace for all of their working time. And of course, if you do get those sorts of applications, no doubt the last 15 months is going to provide some useful evidence, both negatively and positively, and may make it difficult for you to refuse an application for flexible working that includes an element of home working. Now, one thing to watch, and I have seen this, is where employers are able to offer more hybrid and agile working, employees suddenly think, well, actually, I was working part-time because I needed to be home for a particular time for school collections or whatever it may be. But now, if I can work from home more of the time, actually, I could increase my hours of work. Now, an application to increase your hours of work is a flexible working request. And I have at least one client who got caught out on that in the past. So it's just one thing to watch when you are getting those flexible working applications coming through. So, our hybrid working considerations, what do we need to think about? So, as I said, one size is unlikely to work. It's going to be different for different people. And I think the starting point should probably be to have your own sort of thoughts on what you think the workplace should look at like going forward. But you should also have a chat to your employees and think about what they think, what their thoughts are. And of course, you may decide to be completely flexible in terms of the place of work. So employees choose where they work on any given working day, or you may want to be partially flexible. So you can work where you choose for 2 days a week or 3 days a week, but actually we require you to be in the workplace for the remainder. There's lots of different options available to you, and you need to have a think about what you need in your organisation, and it may be different depending on different roles and different teams. But you also need to think about how this will impact on those who can't work from home. You'll in effect result in a two-tier workforce, which could lead to some employee relations issues for those who view working from home as being a bit of a perk with flexibility that they're not allowed to enjoy. And as I say, it involves considerations of what actually do we need. You know, there's lots of advantages of flexible working arrangements where employees can work from home for some or part of the time. You're reducing commuting times. There's an increase in personal and family time. It can improve productivity. But of course, there are also benefits to employees being in their workplaces as well. Lots of thoughts around culture and relationships and how you manage those if you're working remotely. So one option may be to think about a fixed day in the office where everyone comes in, you have your team meetings and those sorts of things as well. Another thing we've seen an increase of over the last 15 months is employees working from abroad who perhaps have family overseas and have found it difficult to be in the UK by themselves. And again, there's lots of things that you need to consider if you've got an employee asking, well, actually, can I remain overseas with my family? I've been working like this for a period of time and I think it works. And I think the key is to treat each request on its own merits. There could be potential discrimination claims if you take a blanket approach of, no, you need to be based in the UK. But you may also need to take some advice on whether an individual who works permanently overseas then acquires some overseas employment rights. And there may also be tax implications if an arrangement that was temporary then becomes long-term. And of course, there may also be immigration considerations as well. So one thing to certainly think about rather than making a knee-jerk response. And as I said, you know, when people are working remotely, whether that's hybrid or permanently away from a place of work, one consideration is how do you maintain your culture and working relationships? And of course, that's been a challenge for everybody over the last 15 months. Again, it's looking at what things have worked in terms of maintaining culture and relationships, what things haven't, how can you address those sorts of things? Do you want to move to some in-person activities and social gatherings where the restrictions allow that or not? And of course, where you have got employees who are working away from a place of work, an office or whatever the arrangements may be, you still retain your obligation as far as their health and safety is concerned. So you need to have a think about, do employees need additional kit if this becomes a more permanent arrangement? There's no obligation to provide employees with home working kit, but of course there may be health and safety reasons why you need to do it. And of course, if you have an employee who's disabled, your duty to make reasonable adjustments may very well include providing kit for home working. And your DSE assessments are still going to need to be completed as well. So that's another thing to think about how you will achieve that. So once you've decided what sort of model you want to adopt, you need to have a think about, do we need to change our contract of employment? Now, if you are changing somebody's place of work, then sections 1 and 4 of the Employment Rights Act are going to require you to update their contracts of employment. And it may present you with a good opportunity to have a general review of your contracts to see if they're fit for purpose and have a bit of a refresh and an update. And one of the things you need to remember when making changes is that you'll need to include all the new things that are required by Section 1 statement since April 2020. If you are changing your contracts, of course, that's formalising your approach to flexible working, which may not be something that you want. So again, it's worthwhile considering it before you make the change. And you also need to think about, do you want to have contractual rights of entry to an employee's home to check your kit, to maintain it, install it in the first instance, and also to get it back if somebody leaves your employment. Other things you may want to think about contractually are strengthening confidentiality provisions. Is there a greater risk when employees are working remotely that your confidential information may be compromised? You may also want to have a think about some of the benefits you may offer. Are they still relevant if employees aren't coming in to a workplace anymore, or only coming in for part of their time? You may want to consider as well having some form of home working or hybrid working policy. There's no obligation to have one, but it sets expectations and requirements. It provides both employees and managers with a point of reference on what your policies are on various points, and the sort of things you may want to consider in a policy are we having core hours where people have to work? Are we being flexible in our working hours? Are we having core days where people have to come into the workplace or not? You may want to think about retaining the right to go back to full-time in workplace working if you decide that hybrid doesn't work for you, and other issues around equipment, insurance, health and safety as well. So then, your reluctant employee. So we've seen lots of surveys over the last 12 months or so showing there's a whole range of views on returning to the workplace. And of course, it's not unexpected that some people will genuinely have concerns about returning to a place of work. It'll present a huge change for some people, particularly for those people who may never have been in your workplace because they've joined you as a remote worker. So whilst you should talk to everyone before a return to the workplace about what their concerns may be, of course your focus should be on those who are reluctant. And the reason why they're reluctant is going to be key. And it's going to be key to managing your risks. So are they saying that they're uncertain or unsure about returning to work because of a physical or mental health condition? Or are we talking about more general concerns? And is the condition theirs, or are they concerned about family members? And those sorts of general concerns may be alleviated by you sharing with them what you've done to make your workplace COVID safe. And it may be an advantage to them if they go into the workplace before everyone else returns to have a look around so that they can see what it is that's been done. If their concerns relate to their own health, or whether that's a physical or a mental health condition, you may need to think about obtaining some medical or occupational health advice to assist you in your deliberations and discussions with them. And of course, bear in mind that if the employee is a disabled employee, you're going to have a duty to make reasonable adjustments, which may be adjustments to your return to work process, and whether you can then require them to return to the workplace or not. So of course you need to understand, as I say, what their concerns are and think about how they can be overcome. If they're saying that their concern is that they could bring COVID into their home or to vulnerable family members or other people they care for, you need to understand that as well. And you need to think about what you can do to alleviate their concerns. And of course, that is going to depend on what the concerns are, but there's a whole variety of things you may want to consider around changing times of work to avoid rush hours, provision of car parking, continued home working. And I think the key is to try and agree a way forward with them, if possible, because it's always better to reach an agreement if you can. And you may want to agree as well the timescale for a review or follow-up, because of course this might not need to be a permanent change. It may need to be more of a phased return to workplace working. But what you need to do is make sure you keep a record of the discussions, what you've offered and why, and if anything was rejected, why that was the case as well. If you can't reach an agreement with them, you need to take care, think and pause before you make any decisions. Because whilst it may be a reasonable management request to require somebody to attend their place of work, either full or part-time, it's not entirely straightforward and is going to be very dependent on the reasons they are giving for refusing to return to the place of work. And of course, if you can't reach an agreement, they may go off sick, they may resign, they may raise a grievance, and there is a risk of claims if you don't pay somebody because they're refusing to attend the workplace, or if you take disciplinary action. So you could face claims for unfair dismissal, automatic unfair dismissal on health and safety grounds, or disability discrimination claims. So I think the key is not to sort of have a knee-jerk reaction and to just think about what the reasons are, what the alternatives are, and to make sure it's carefully documented, and to take advice if you're concerned about the risk. So one of the other issues that we may see going forward relates to holidays. Obviously, at the moment, we have this traffic light system that I understand the government is still looking at. If we could just move to the next slide, please, Tom. And one of the things you need to think about as an organisation is what your policy is going to be if you've got employees who travel to green, amber or red countries for holidays, what will happen if they change, and how you will deal with any quarantine requirements on their return to work. Because of course you can't allow somebody to come into your place of work if they should be quarantining or isolating. But of course there are also implications of banning employees from travelling to those countries. They may lie to you about where they're going, but also there could be mental health implications if actually the reason for travel is to visit family members that they've not seen for a while. So you may want to have a look at your annual leave policy, have a think about what your position will be. Do you need to make any changes? And in particular, you may want to include things around requiring employees to tell you where they're travelling to, whether you're going to pay them during periods of quarantine on return from holiday, particularly if they need to physically be in a place of work or not, what you'll do if the rules change whilst they're abroad, and also around your ability to refuse requests for annual leave. Okay. Then finally, I just wanted to touch on the changes to furlough, and just to remind you that from next week, so July, the position with furlough is going to change. So at the moment, if you are still claiming furlough, if we can go to the next slide, Tom, you can claim up to 80% of the furloughed employees' wages to the maximum of £2,500. But of course, that is going down from the 1st of July. It will be 70%, and then it will reduce again for August and September to 60%. And at the moment, the scheme is currently due to end on the 30th of September. If you think that you may have got your furlough claim wrong, I think the key is to act now. And the starting point may be to watch our webinar on furlough fraud. And again, that's available on our YouTube channel if you've not already seen that. And of course, linked to that, you may be thinking that actually when furlough comes to an end, we need to make changes to staff numbers and hours. And if that is the case, now's the time to start planning, because of course, if you're contemplating dismissing 20 or more employees as redundant, you're going to need to do a minimum of 30 days consultation before you serve any notices. If the situation is worse than that and you're looking at 100 or more employees, it's 45 days minimum consultation. So you need to factor those timescales into your planning. Okay, so I'm going to hand over to Gary, who's going to talk to you about all things immigration.
Thanks very much, Claire. Right, hi, I'm Gary from Latitude Law Solicitors in Manchester. I've just got a few slides, obviously completely different to what's gone before, but please bear with me. We're going to talk a little bit about the various routes and options that are available for employers and for the overseas staff that they employ or might wish to employ. So starting first with the EU settlement scheme, I'm sure most people will be familiar with this. So there are two forms of status you can get under the scheme, either settled status, which is for somebody who's been living in the UK for 5 years or more, and pre-settled status for somebody who's been here for a shorter time. This is all EU citizens except Irish citizens. Irish citizens are not covered by the scheme. They have rights to live and work in the UK automatically because the Republic of Ireland is part of the common travel area, which is the island of Great Britain and Ireland. You might still see some people eligible to apply for pre-settled status. The basic rule is that they must have been living and working in the UK before the end of December 2020. And what we would normally advise is that somebody who's been in the UK in the last 6 months of 2020 is potentially eligible. Now, it may be arguable that somebody who was here earlier than that and who's gone home, perhaps due to the pandemic, and has a longer absence from the UK could still be eligible for pre-settled status. So because this is kind of the high watermark of status, because it's obviously, it's kind of a free kind of work visa, it allows the individual to do whatever activity they want in the UK, it is worth having if your employee is eligible for it. So always worth checking and perhaps supporting the individual employee to make an application under the pre-settled status scheme. The last point on the slide mentions a soft deadline. So you may well have seen in the media the fact that the 30th of June is a deadline. So we move to the next slide. We just look at why it's a soft deadline. So what the UK government's done is it's introduced a scheme that's more generous than it needed to be under the EU withdrawal agreements. You can contrast that with the rules that exist in other EU countries for British citizens who are living and working there. The EU member states tend to have applied the withdrawal agreement provisions much more strictly than the UK. Now, that's led to a large number of applications under the EU settlement scheme, 5.2 million, I think, last I heard, which is way higher than the government estimated for the number of EU citizens who even were in the UK. So it's an interesting statistic. And I think what's partly driven that is the fact that EU citizens who have previously worked in the UK, who've gone home, are taking advantage of the EU settlement scheme and applications under that for pre-settled status. So the 30th of June is a soft deadline because the government has also written in provisions to the immigration rules to allow EU citizens and their family members to apply after the 1st of July this year under the settlement scheme. It's kind of hard to generalize about this. The rules are perhaps overly complex, perhaps more complex than they needed to be. So there'll be individuals and perhaps family members of EU citizens as well who are going to be eligible to make applications after the 1st of July. So that deadline that's rapidly approaching isn't necessarily the end of the story so far as the settlement scheme is concerned. The general kind of principle in the rules is that if you are applying after the 1st of July, you need a reason. And quite often that reason is going to be COVID, I think. And that's been confirmed by the Home Office in guidance as an acceptable reason for applying late. So, you know, say somebody's stuck in their own country and they're looking to come back to the UK, they may well be able to apply after the 1st of July. And also bear in mind, it is possible for EU citizens and some family members to make applications even while they're in their own country. They don't necessarily need to be in the UK to make applications. Okay, next slide, please. You will all be familiar, no doubt, with your duty to perform right to work checks on your staff. These obligations continue. The provision, the kind of COVID concession, which related to the ability to see somebody via a video call and to receive electronic copies of their identity and right to work documentation. That's been kind of successively extended. Current expiry of that option is the end of August. It's likely, in my view, because it's been extended so many times, that that's going to be extended again, which is just really a reflection of the need to take on staff who perhaps aren't coming into the office and perhaps you're not seeing face to face. Remember also that with EU citizens who work for you, all you've had to provide up until now and up until the end of June is proof of identity, which can be a photo page of the passport or a national identity card. That's all an EU citizen has needed to prove a right to work. Now, it's not going to be necessary for employers to kind of retrospectively go back from the 1st of July and conduct additional checks on those EU employees. So you don't need to worry about that, which is obviously a good thing. Okay, moving on, Tom. Just going to look at a couple of other options for EU citizens, and then my final slide is an option for any overseas national looking to work in the UK. The Frontier Worker Scheme it's a brand new thing for the UK. It's been around in mainland Europe for a few years, but it's kind of come to the fore because of obviously Brexit. And a Frontier Worker Permit is typically relevant to EU nationals who are contractors who come to the UK to perform specific duties. They might be installing machinery, they might be maintaining machinery, that kind of, so it's that kind of work profile. So somebody who's resident outside the UK, but who has a regular need to come to the UK to perform work tasks. So again, they must have had some presence in the UK before the end of the Brexit implementation period, so 31st of December last year. And as the slide says, must have worked in the UK at least once every 12 months. Now, normally it's preferable for them to have been present in the UK during 2020, but again, because of the pandemic, there is a concession in place, and the Home Office will look at Frontier Worker Permit applications where somebody has worked in the UK last in 2019. We've acted for a number of employers who get a number of EU citizens over on specific short or medium-term contracts, and they weren't required during 2020. They will be required during 2021, and we're successfully applying for Frontier Worker Permits for those EU citizens. So again, it's a good option because you don't have to sponsor that particular worker. Once they get a Frontier Worker Permit, it's valid for 2 or 5 years, and they can do whatever work they want to while they're in the UK. Okay, next slide. Now, this again is something we're advising a lot of our business clients on at the moment, and it's the entry to the UK. This is not just EU citizens, this is any foreign national as a business visitor. So you'd think it'd be quite straightforward, somebody coming to the UK to conduct business, but as with many aspects of the UK's immigration rules, it's a lot more complicated than that, unfortunately. The general rule for visitors, as you may know, is that a visitor is allowed entry for up to 6 months. And if we use EU citizens as an example, they're not visa nationals, so they're not required to get a visa before they travel to the UK as visitors. They just present themselves at the air or seaport, and they are admitted by the Border Force officer, or they enter through an e-gate. Now, business-related trips, in the Home Office's own guidance, it suggests that a maximum of a month is appropriate, but that's very much rebuttable. That's very much a starting point. So don't think a business trip is limited to 1 month. And when I say business trip, we'll see in the next slide that that encompasses a lot of different activities. It's not just coming to the UK to attend a meeting. So if there is a genuine business need for somebody to be present in the UK for longer than a month, then that will be possible. And I'll talk in a moment about the kind of advantage of invitation letters, something you've not perhaps had to deal with your EU business visit contacts in the past, but something that might be necessary in the future. The one strict rule in relation to business visitors is that they can't come to the UK and be paid by a UK company for their for their activity. Let's call it activity, because work is in theory not permitted, but there are kind of exceptions to that. The final point on that slide, paying an overseas contractor's invoices, we would say yes. The Home Office rules and the Home Office guidance isn't crystal clear on that point, but if you're having somebody over, you know, for example, to do an installation of equipment that overseas contractors supplied, then paying that invoice is going to be okay, because obviously you're not directly paying the individual workers who are coming to the UK. So the next slide talks about permitted activities. These are a few of them. You'll appreciate that the immigration rules, they can't cover every eventuality. So it may be appropriate, and obviously we'd be happy to advise on particular activities that individuals may be coming over to the UK to perform. Then second point there about visas before traveling. Now, as I said, with EU citizens and for a lot of nationalities, it's not necessary to get a visa before travel. For some nationalities, it is a requirement, but that's all contained in the immigration rules, which countries are visa nationals and which are not. And finally, on that slide, the idea of a compliance pack, it's something we've kind of worked with business clients on in recent months, and it's quite a popular option really, because they might have a contractor coming over to the UK to perform certain tasks, and they don't want that contractor or team of contractors often to be stuck at an airport and being held or potentially being refused entry to the UK. So a compliance pack would typically include a letter of invitation, might include a copy of the contract or purchase order under which the individual is working under or going to work under. And it might also include legal advice, a letter of advice, which considers the proposed activities and advises that those activities are allowed under the business visit immigration rules. Okay, so the final slide I have today relates to sponsorship, what the government refers to as its points-based system for sponsoring skilled workers. A couple of key points that have changed perhaps since you last had an opportunity to look at these rules are that the skill levels, the kind of threshold skill levels have reduced since last December. So it's basically kind of A-level sort of high school type occupations which are covered by skilled worker sponsorship now. It used to be sort of degree level and above, which were all that was sponsored, able to be sponsored. And threshold salary levels have gone down as well. So I mean, very broadly, there's quite a lot of nuance to this, but very broadly, for a younger employee, so under 26, or somebody switching from education into employment, you've got a salary threshold of just over 20,000, and for a more experienced worker, you've got a salary threshold of about 25,500. So those are the kind of figures you're working with, and I'm sure a lot of you will be familiar with the sponsor licensing regime. What used to be tier 2 is now just called skilled worker. and you've also got the intra-company transfer for multinational operations. Skilled worker sponsor licenses, they're kind of easier to get now. The Home Office has kind of recognised that a lot more employers are having to engage with the sponsor licensing system. It's streamlined the process for applying. When the Home Office does streamline it, it doesn't really streamline it that well, to be honest, but it is better than it was. Processing times for a sponsor license application, standard would be 8 to 12 weeks. So you need to kind of factor that into any recruitment processes. There is an expedited option, but it's kind of 10 companies per day, 10 applications per day are allowed to go for priority processing, which is 1 to 2 weeks. So it's a little bit of a lottery, and it can be quite difficult to get on the priority list. And finally, there are not just T5. What used to be Tier 5. T5 is the temporary worker sponsorship option. So there are a number of different routes available here. This is for short-term sponsorship. So it's something to bear in mind if you're not looking to recruit somebody for more than, typically more than 24 months. T5 short-term sponsorship is for between 12 and 24 months. So if you think that you may have a need for recruitment for a shorter period, then T5, not just international agreement, there are other aspects of T5 might be the kind of licensing that you need. So as Tom mentioned at the beginning, we are kind of happy to answer any questions from employers about what I've talked about today, and yeah, look forward to hearing from you. Thanks very much.
Thanks, Gary. Really appreciate that. Really interesting stuff that I'm sure people will have taken a lot from. I'm conscious that we've just snuck over 11 o'clock, so thanks for sticking with us, everyone. I'm not going to keep you for too much longer. Just to say thank you to all the speakers from today. So the three guys from Kuits. So thanks to James, Lauren, and Claire, and obviously thank you, Gary, as well. Just to let everyone know, there will be, as I said earlier, a follow-up email coming round to everybody with all the contact details on from the speakers today. Also a copy of the slides, and then later on, once it's been processed, also a link to view the recording as well. As Claire mentioned, we'll also send around a link to the misuse of furlough webinar that we recorded last month. Again, if you haven't seen that, hopefully you'll find that really useful. The next Kuits HR Breakfast will be in September of this year. So you'll now be on the mailing list, hopefully for all our HR breakfasts. So yeah, make sure to look out for that. Again, if you've got any questions based on any of the content in today's HR breakfast or any other HR or employment queries, please get in touch with us. And just to say thank you again to our speakers, and thanks very much for attending, and we look forward to seeing you again soon. Thank you.